If I may seek your Lordship indulgence, with regard to item 2 of part 2, I've talked to the counsel for the other side, and if the matter can be taken up for hearing on Wednesday. So, MAC appeal.
Wednesday is GB day.
On Thursday, if possible.
Okay, during this week on Thursday.
Friday, Thursday is holiday. Thursday is holiday, Your Lordship.
So tomorrow, what's wrong tomorrow? Come tomorrow.
I don't
Okay,
know,
on
Your
a Friday. This week, anytime.
This
We'll
week
try and make
anytime.
it on Friday.
My Lord.
If I may seek for your Lordship's indulgence in mentioning item number 7 and 11 of part 2.
What happened?
Lordship, my senior, Mr. Johnny, has some personal inconvenience, and if this matter may be taken up after the vacation.
Have you spoken to the councils for the other side? Yes.
I'm for the appellant in item 11.
11. What about 7?
I'm for the appellant.
So consent?
Yes.
Okay. Mention is made on behalf of Mr. Johnny L. Tokchong in 7, learned counsel for the respondent for adjournment of the matter with the consent from the other side. In view of the above list, after the ensuing vacation.
Oblige.
Then same order, N number 11. Back appeals, simple matter, yes.
Your Lordship, if I may take indulgence regarding item 12 of hearing list, that this matter may be taken up tomorrow.
Okay, this week.
Much obliged. Yes, tomorrow.
My Lord, in respect of part 2, item number 14, can this matter be listed after the vacation? I have already taken the consent of the parties, my Lord.
You're the amicus curiae, isn't
Yes,
it?
yes, my Lord.
Okay, on the prayer made by Mr. Lal Ramdin Thara, learned amicus curiae for the appellant. List this matter after the ensuing vacation.
Deeply obliged.
It is submitted that consent of the other side is also taken. Yes.
My Lord, this item number 3, I am for the appellant. This may be passed over for the day.
Okay, so for the day, we leave it during this week, anytime
Yes,
you
my
come
Lord.
up.
Yes,
For motion, supplementary cost list, item number 9.
Oh,
Make this
correction of the cost
Yes,
title.
madam. I've made the state of Mizoram, the Home Department as a party, madam.
Okay.
This is for quashing of the complaint petition, madam. Here what happened, madam, we have received the notice from the respondent number 2 to debit freeze the account. Now after a few days, madam, there's another order from the same police in the court in Tamil Nadu, madam, where they're saying to refund the amount, whatever is left in the account. And in the meantime, the same complainant have also filed a civil suit, madam, which your Lordship will find at page 47, madam, for damages. I mean, in view of all,
Will issue notice first,
my lord,
isn't it?
yes, my lord. In view of the multiplicity of proceedings, my lord, all over, my lord, we are caught in between, my lord. One court says to defreeze, one court says to hold the amount, my lord.
Which court says to
My lord, in
defeat?
court in Tamil Nadu, my lord, Saidapet Magistrate, which your Lordship will find at page 45.
Page 45.
45, my lord. There's a direction to release the amount. As your Lordship brought it, page 45, Annexure 7. My lord, as per the order of so and so, the investigation officer is ever directed to issue necessary direction to the concerned bank to defreeze the below mentioned bank account number and to transfer the said amount or if it's less than the same, the remaining available balance amount to the account of so and so and submit a report forward. Here, my lord, it's serial number 1. And if your Lordship may come to page 47, again, my lord, the complainant, the present complainant, have filed another civil suit for damages for defreezing the account. And there is an order under there's an injunction, my lord, not to transfer the amount, which your lordship will find at page 55, my lord. Operating portion. My lord, from the beginning, on the third line I'm reading, my lord. Also considering the said prayer for an interim, as it is of the urgent nature, this court allows the an interim prayer of the counsel for the applicant and directs the opposite party to maintain status quo and not to dispose any amount till hearing on the point of injunction or till any other further order. So, in top of the civil suit, my lord, the present complainant have also filed a criminal petition for taking cognizance under 318, my lord. Here in the
What
complaint.
I'm not understanding is this Chennai, the one which you showed me.
Yes, my lord.
This is,
This is the Metropolitan Magistrate in Chennai. There is a direction to the investigating officer, and the investigating officer, response number 2,
to
having
defreeze the said amount,
said
isn't
amount
it?
and to transfer to the so and so account. And my lord, the court here has given an injunction not to transfer the amount, my lord. And we are caught in between, my lord. In view of this, and they have not made the Superintendent of Police Tamil Nadu party in both the complaint petition as well as a civil suit. The response number 2 will be the best authority to answer the allegations, my lord. As of now, we have no objection to defreeze, but the criminal complaint against the bank, my lord, that's why we are here.
So now this bank account number,
My lord,
it's in the name of this person?
respondent number 3, my lord.
Respondent number 3.
3, my lord. In the same respondent number 3 have
Okay,
also
it's in the name of respondent number 3, this bank account,
Ma'am.
HDFC, is it?
XDFC, my lord.
Which is amounting to what, 27
27
lakhs?
lakhs.
Now here this court says to defreeze the said amount.
My defeat same amount and to transfer
And it's
amount.
addressed to,
My lord, to one here, my lord, to one name, to transfer the amount to Axis Bank account, my lord. If it in the direction, my lord.
defreeze the loan amount, I want to say that.
To the account amount of de facto Axis Bank number so and so.
So against whose name is this?
My name we do not know, my lord. In all likelihood, my lord, the DK Chandrasekhar, my lord, I think de facto. complainant.
So, this is an order of the court,
My
isn't
lord.
it?
Yes, my lord.
To defreeze, so it's addressed to you, is it?
My lord, it is addressed to the superintendent police. The superintendent of police have attached this order to us, and they have been following up on daily basis to transfer the amount. Now, with the difficulties, there is another order from this court, my lord, the civil court in Kolasip, not to transfer any amount, which your lordship will find at page 55, the operating portion. The respondent number 3, my lord, he knows that the reason why we have freezed the account, my lord. In spite of that, he has filed another complaint case, my lord. At page 55, my lord, after considering the said prayer, is of the urgent nature, this court allows the Indian prayer of counsel for applicant directs the opposite party, that is us, my lord, to maintain status quo and not to dispose any amount till the hearing on the point of injunction or any other further order. Man, that's why my notice maybe issued to the response number 2.
We'll issue notice.
My lord. Because they have not made the state of Tamil Nadu party in both the cases, my lord.
But this is very weird, this account number, isn't it?
Yes, my lord. The prayer, my lord, page 52, my lord, in the same injunction, the same account number.
So the plaintiff in the civil court.
Is the complainant, is the response number 3.
So what did he want?
He want to defreeze the account. That is the
Defreeze
same
the
prayer in the
account.
complaint petition, yes, my lord.
So
That-
he wants to defreeze the account,
My lord.
which also was allowed by the
No,
Metropolitan.
no, it was not allowed, my lord. The only, not to transfer
Oh.
the amount. The Metropolitan Magistrate have directed
To
to defreeze
defreeze
this
the said amount.
and then to transfer to
Transfer
the
transfer
complainant.
it to some account.
account, my
Is
lord.
it?
Yes, my lord.
Now, in the civil case, he had prayed for defreezing the said amount
And also
not
for
to
damages.
transfer.
My lord, he has filed a civil suit to defreeze the account as well as for the damages. in the main suit. And under Order 39, there's another case in the current place. There the court has directed not to dispose of any amount. So we have, the amount is there, Manoj.
What's the amount?
Not to
64
transfer
lakhs.
that 64 lakhs, but here the court has directed not to dispose of any amount. I think
one,
yes.
in one it's 27 lakhs.
Yes, my lord.
Now here it's 64 lakhs.
My lord.
So you have what? You have freezed the account amounting to 64 lakhs.
No, we have freezed the whole account only. The whole, it's on debit freeze, my lord.
The whole account.
He cannot transfer.
What is the amount?
My lord?
What is the amount?
Amount, my lord, we don't know how much amount is there lying in the account of the respondent number 3, my lord. In all likelihood.
Simply froze the whole account, while here it is only regarding a specific amount, isn't it?
My lord. If you,
so the letter received under which you had frozen the amount, where is it?
my lord, at page 39.
It's very complicated.
My lord,
What
that's
is
why, my
going
lord,
on?
the respondent number 2 has to us. In fact, this is not the first case, my lord. There's been lots of multiple cases going on regarding the cybercrime, where bank, the police authority, they give us the direction not to freeze the account, and they don't follow up. And then what happens, my lord, they complain in the customers. They are filing complaint cases, civil cases, different cases, my lord. In fact, this case, my lord, it might set a precedent regarding the issues, my lord, what the bank has to do. My lord, now on top of that, they have filed a complaint petition. Here, my lord, we are on that. And let the notice be issued, my lord. Let the respondent number 2 and come and answer.
Okay, we'll issue notice. Let's see what is going on. I'm
Yes,
really not quite understanding also what is the whole issue.
Well, there is a notice from the Tamil Nadu police to freeze the account, and we have freezed accordingly.
Okay.
Now they have given another email, my lord, notice. That is, your lordship will find at page 43. Now they are asking us to defreeze the account and send the amount. This is the email, my lord. And they have also
So
attached,
you're basing only in the email, isn't it?
my lord.
So you are relying only on an email. Authenticity of this email also will have to be seen.
My lord. That's why, my lord. And at page 45, my lord, this is a court order also. That looks genuine.
To freeze the amount, you ask and send it to some other account,
Yes, my
isn't
lord.
it? So this account, then we'll have to see whether this thing, because there's so much of fraud going on.
My lord.
So this supposedly email
My lord.
from Tamil Nadu Police Department
My
also,
lord.
you have to see whether this is
Yes, my
correct or
lord.
not.
If they don't respond, my lord, the lordship may direct us to defreeze the account. We don't have any objection. At this
Because
moment,
this could be just a fraud, I'm saying.
My lord,
to
that may be.
freeze so much amount and send it to this
my lord,
account.
My lord.
What is that? If you send it to that account, who does it belong under what? I don't think that's the appropriate. Anyway, we'll issue notice
My lord.
because this email which you are receiving
My lord.
could be
This
some
might
fraud
be,
also.
may not be, my lord, we do not
Because
know.
do you act on just an email?
My lord. My lord, even, my lord, we have the instruction, my lord, if any cyber crime has been reported in the NCRP portal, that is National Crime for,
Yes,
we are,
yes.
means we are directed to defreeze the account of the disputed amount. That is what the instruction are. But as of now, there is no specific as of
No instruction is
No
received
instructions,
yet.
my lord. So, my lord, no next date, my
So
lord.
freezing and defreezing also, whether it's from the appropriate authority.
Yes, my lord.
The appropriate authority will obviously be the Metropolitan
My lord.
Magistrate's order to defreeze.
My lord. And the
But
courts, my
to
lord.
transfer it to a certain account,
My lord.
so how did you receive this order from the Metropolitan Magistrate? Was it through an email again?
My lord, we have received the order through email only. That's what, my lord,
Through
we
the
are.
email.
Let the.
So do you send orders of the court through email?
No, my lord. That's the thing, my lord.
Then it has to be a certified true copy.
My lord. And my lord, we
So I
have
don't
been.
think you have to take all that very seriously. I don't know.
My lord, there have been multiple cases, my lord, regarding all this. That's why, my lord, we are here before your lordship, my lord, to guide, my lord. And now on top of that, there is a complaint petition, my lord. Let the notice be issued, my lord. If they don't follow up, definitely the lordship may direct us to defreeze the account.
So now you have approached the CJM also, so what, JFMC regarding this?
My lord, we have not
A
received the
complaint was made, isn't it?
My lord.
To the JMFC. So the JMFC has not taken cognizance of this matter till date. You are supposed to appear,
My
isn't
lord.
it?
My lord.
So when you are appear and this criminal complaint which is filed against you
My lord.
could also be dismissed outright. So now your main petition is for setting aside
The complaint
case,
petition.
the complaint. But isn't it for the JMFC to decide
My lord,
when cognizance has not been taken yet?
my lord.
So when you appear before the JMFC,
My lord.
if the JMFC finds that this complaint doesn't have any basis on their own, without coming to this court also, the JMFC cannot take cognizance of this complaint.
My lord, that we do not know, my lord, whether they are taken. We are here before your lordship, my lord. As was this, for quashing, my lord, the lordship have no bar. my
No,
lord.
we'll issue order first,
My lord.
okay? And we're not going to issue any stay because you have to have faith in the trial court also. The trial court also, we can do the same thing which this court is going to do. Issue notice,
My
call
lord,
for the
issuing
parties,
notice without this- My lord.
examine your case, and if it finds that this criminal complaint files against you doesn't have any basis, it can dismiss the criminal complaint
My lord,
also.
if it does not dismiss, my lord, but
If it does not dismiss, so you
My
have
lord,
to
if
wait
I-
for some time, isn't
But
it?
if I may, if your lordship may allow me to produce one judgment of this honorable Supreme Court, my lord,
Let's see
regarding
now.
data threshold. My lord, 1996, 5 SEC 591, this has been relied on.
So, if the JMFC takes cognizance
My lord.
and you're aggrieved,
My lord.
then you approach this court. Now nothing has happened. It's only summons
but-
that issued. You explain yourself.
But in this summon, my lord, there is an, if your
What?
lordship
What
may
is-
look at this summon, my lord,
What is
that's
the
been, we've been answered, we've been summoned to answer charge, my lord. We do not know, my lord. I mean, if you, at page 57,
57
of my
of the
criminal
petition.
my lord.
Yes, someone
Summoned
has
to the
been given
accused,
to you.
I mean, whereas attendance is required to answer charge under 223 BNS.
So you go, and then because this is a complaint that is served, you appear before JMFC, you have explained the reason. I think it's for freezing of the account of the complainant, isn't it?
Yes, madam, the same
So-
complainant have also filed a civil suit in the there, we have an injunction, my lord.
So
But
you
it-
mentioned that also before the JMFC. The JMFC, there's already a civil suit, so
yes.
the complainant doesn't have a case, can dismiss your case straight away.
That may be, but if your lordship
Maybe,
may,
yeah,
my-
it can happen. You appear before the
my lord, if your
JMFC,
lordship may
you
come to the,
insist.
decision, my lord,
okay.
1996, 5
Yes,
SEC,
yes,
591,
yes.
my lord, paragraph 26, my lord.
26.
Even this case has been relied on, my lord.
Okay, so what does it say here?
My lord.
Huh.
After giving our careful consideration to the facts and circumstances of the case and the submission made by the respective counsel for the party, it appears to us for the purpose of quashing of the complaint, it is necessary to consider whether the allegation in the complaint prima facie make out an offence or not. It is not necessary to scrutinize the allegation for the purpose of deciding whether such allegations are likely to be upheld in the trial. Any action way of quashing the complaint is an action to be taken at a threshold before evidences are laid in support of the complaint. For quashing the complaint by way of action at the threshold, it is therefore necessary to consider whether on the face of the allegation a criminal offence is constituted or not. It's just made there's no bar before your lordship, my lord, to consider my case, my lord. That is my humble
Anyways,
submission.
we'll issue notice first, isn't it?
Yes, my lord. My lord.
Yes.
In the meantime, my lord, the complaint petition, proceedings may be stayed, my lord.
No, we will not stay because, it could become infractious by itself if the JMFC considers by the next date, your matter could have already been decided.
My lord, my respectful submission, if cognizance is taken, my lord, then again
If it is taken,
My
it's
lord.
not taken yet, that's what you said. No, the magistrate has not taken cognizance of the matter yet.
Well, in the
Suppose-
meantime, in view of the multiplicity, there is a civil case. That's just my respect to submission. The complaint petition may be state. We are not challenging the order of the civil court. Only the complaint petition may be state in order to enable us to file an effective written statement to the civil case, and also know the reason what is going on.
So I'm just wondering why you're so scared when you feel that there's no case against you.
But that is why we are before a lordship, because
So
we have
if you
been
feel-
sandwiched in between.
Then I'm saying, why don't you have faith in the JMFC?
We have faith in
So you appear before the JMFC, explain the matter, and then the criminal complaint could also, we have to still hear anyways, could be set aside straight away.
it may be set aside,
then-
but we are here before a lordship. In a view of this,
So we'll issue
submission-
notice here,
Madam.
we're issuing notice just in case you feel that the JMFC had wrongly taken cognizance of the matter. So for that, we will issue notice. But I have a feeling that next time you come, if you say it is what you are saying it is, then by the next time, next court date, this, revision matter could have become infructuous also.
it may not be. Suppose the
So it may
cognizance.
not be, but it could.
It could. But suppose we are here.
Supposing it's not,
It's
then
not
by the
there. They
next
know-
date, after issuing office, notice, your matter can be settled.
If it's not, if the cognizance is taken, we'll be required to furnish our bail bonds on the very next day. But that is the difficulty. But in view of the several cases been going on in Tamil Nadu.
So supposing cognizance is taken, then what? Then investigate, there'll be an order to investigate into the matter, isn't it?
we'll be allowed to. We'll be required to take bail, before
No, bail will not be required, that's not the system. Cognizance
if
is
the cognizance is
taken-
taken and accused to the both cluster head and the branch manager, it is not that only.
No, he'll not be arrested straight away, I don't know, that's not the way it is.
Arrest is not an issue, but
Then, what bail, matter of bail doesn't come in yet.
even for the purpose of appearance, we have to take a personal ban before the JMFC in order to discharge. And here, we are
So
acting.
you're from Colisib, isn't it?
But
Isn't it the Colisib Bank?
Yes, Colasib branch,
Then-
HDFC bank
Then
branch
the
manager.
officers of the Colisib Bank will appear before the magistrate first class. Anyway, we'll issue notice first. Okay. Heard, Mr.
M. Smith,
M. So-and-so, learned counsel for the petitioner who has filed the instant petition / application under section 528 of the BNSS, 2023 for quashing the complaint petition bearing criminal complaint case number 20/2025 pending before the learned
JMFC,
Chief Judicial, it's the Chief Judicial, CJM, Chief Judicial Magistrate, Colisib, Mizoram.
It is from the summon, it looks from the JMFC.
But here you're saying in your
Chief Judicial Magistrate. Sorry,
CJM. So are you sure? Is it the CJM of
Malad-
JMFC? I'm also saying JMFC because what you're showing
Yes,
is
Malad,
J-
actually, I'm sorry,
But in your
like-
petition, you say Chief Judicial Magistrate.
It should be JMFC,
So again, here, this thing is wrong. No, let's see. No, I think she will be the JMFC. No, this is a civil case.
But this is civil case,
Civil is before the senior civil judge.
The
And
complaint
then the
petition
order,
at 39,
Page 39.
Sorry, 31.
The summons that was served to you is page
Page 57.
37.
57,
57. It is the JMFC. But in your petition, you have mentioned Chief Judicial Magistrate, isn't it? Anyways, so it is issued by not Chief Judicial, but the Judicial Magistrate First Class, okay, within brackets JMFC. See, again, mistake you've made here. Anyways, no full stop. Then the learned counsel for the petitioner submits that see, everywhere you have mentioned Chief Judicial Magistrate.
Man, on the next date I'll correct it, man, file the application.
The complainant had filed the complaint against the petitioner for the alleged commission of an offence under section 223 BNS, is it?
Man, if your lordship may come to 223 BNS, it doesn't make it's completely different. What does the 223 says, if I may?
No, whatever, but it's been charged.
Madam,
isn't
here
it?
in the
A
compla-
complaint under 223, isn't it?
My lord, here in the summons, we have been asked to answer charge under 223 BNS. If your lordship may come to page 34 of the complaint petition, they are seeking to take cognizance under if your lordship got it, page 34, my lord.
34. Yes.
My lord, para 11, my lord. Para 11 D. The action of the office amount to under section 318, 320, 323 of BNS, my lord. And now in the summon, we have been asked to appear to answer charge under 223 BNS. My lord, 223, what does 223 says, my lord? Here?
But 223 is also there in para 11, isn't it?
My lord,
So maybe the court thinks it's 223 is enough. What's 223?
223,
BNS?
my lord, yes.
BNS.
BNS.
What does 223 say?
My lord, it says, a disobedience to order duly promulgated by public servant, my lord. Whoever knowing that by an order promulgated by a public servant lawfully empowered to promulgate such order, he is directed to abstain from such a certain act or to make certain order which certain property in his possession or under his management disobey such direction. But no way related to.
Oh, okay.
I mean-
So anyway, notice, that's why I'm saying,
My lord.
if you feel that nothing related to it, then you appear before the JMFC, explain yourself, and maybe you could get the whole thing squashed instead of coming to this court. Anyways, 223, is it?
My lord, 223, where my respectful submission, this 223 doesn't even apply here, my
No,
lord.
so that's why.
That's what, in view of this, all the confusion, we are here before your lordship, my lord.
No, but you have the forum where you can appear before the JMFC also.
Well,
It's
we-
only the stage of issuing sermons. That's why come to the High Court straight away when you feel that you have a good case before the JMFC. That's what I'm trying to
Yes, my lord.
figure out.
Yes, ma'am. In all my
Okay,
respectful submission.
So have faith in the JMFC, and then at that stage, because this petition is simply for setting aside the criminal complaint. Now, we are not looking into the civil matter, all
My
that,
lord,
isn't
we
it?
have- yes, my lord.
So if you appear before, anyways, if you want, we'll issue notice,
My lord.
but we'll not stay the proceedings before the JMFC, because I think you should have enough faith before the JMFC also,
My lord,
that if you find that he finds that there's no case, then criminal complaint at that stage itself can also be set aside before the JMFC. By the time notice is issued and next date is fixed, this matter can also become infructuous. That's what I'm trying to say. Why
Yes,
burden this
lordship is
court?
absolutely correct. It might not become infructuous, but there is also the other way. If it doesn't, my lord,
If
that's,
if it doesn't, that's why, if it doesn't
In-
happen, we'll issue notice and we'll see. But in the meantime, I don't think there's a reason to to state the proceedings before the JMFC. But if it's not set aside straight away or squashed, then you have the alternative here, isn't it? Double protection you're trying to make. Anyways, what's it? 232, is it? Section 233 BNS.
223 BNS. my lord.
223 BNS. Against the petitioner on the allegation that the bank account, is it?
Yes, my lord. Of the complainant. Of the respondent number 3, my lord.
Wait, where is it? That the bank account of the complainant. Where's the bank account number?
My lord,
See,
page
because
30.
it's so detailed, your petition, I'm trying to find
Page
out.
32, my lord. Here, my lord, the cause title.
Your the petition you filed itself, it's too detailed, so I'm trying to find out from your petition which
My lord-
part would be important for the first
Yes, my
order.
lord. Page 32, my lord.
Page 32. On the allegation that have you mentioned all this in your petition?
My
Your
lord.
lengthy petition?
Yes, my
You have
lord.
mentioned, where, which para?
My lord,
This bank account number.
my lord,
First, we'll have to look into your
para
petition.
3, my lord.
Para 3. Very lengthy, isn't it? Okay. For freezing the bank account of the complainant account number 501006119463737 without due process of law. And for taking cognizance under section 318/320/323 of BNS 2023. The learned counsel submits that the petitioner has been issued summons to appear before the court of the learned JMFC for answering the charge under section 323 BNS.
But 223, my lord.
Oh, yes, 223 BNS. Whereas no offense under the said section is made out. The learned counsel submits that the said criminal complaint filed against him has no basis and is liable to be quashed and set aside
At the threshold.
straight away at the threshold. Issue notice to the respondents through.
Yes, my lord, as I already mentioned in the last court date.
We'll
by
just issue
looking-
notice, the next court date you see, okay. Issue notice to the respondents. Ms. Vani Isyami, learned counsel for the state respondents accepts notice on behalf of respondent number 1. Notice be issued to respondent number 2 and 3 through registered post with AD within 3 days,
Yes, ma'am.
okay, returnable by 3 weeks. Let's make it 4 weeks because vacation will be also be there. Returnable by 4 weeks, list after 4 weeks. The learned counsel for the petitioner has also prayed for staying the operation of the criminal complaint filed against him before the JMFC and registered as,
Criminal complaint number 20.
has it been registered?
My lord, criminal complaint number 20 of 25, my lord.
Okay, as criminal complaint number 20 of 2025. This court finds that the prayer for staying the proceedings before the JMFC at this stage is not required and may be considered in the next date if necessary. list after 4 weeks. Yes. You're getting my point? Because I have a feeling if it's as simple as you say it is, then before the JMFC also, they can not take cognizance, then this case, by the next court date, you can pray for it to be withdrawn since it's becoming fructious.
I'm only
That
worried
can
about the
happen.
other part.
But if it doesn't happen, then yes, case is still there. Then we'll see whether it should be stayed or not by the next date, isn't it? Yes.
Ablash.
Formation. Item number 1.
May I please, Your Lordship?
Yes.
Yes, Lordship, this regular first appeal arose out of a civil suit number 171/2023, Lordship. Case is that, Lordship, the defendant number 1 awarded the contract work for construction of Ekolobya Model Residential School, Jalwam, Mizoram, and Lordship, amount is rupees 4,88,51,514, Lordship, and another amount is 3,46,39,222, Lordship. Accordingly, Lordship,
What, huh?
the respondent number 1, Lord,
Oh.
respondent number 1 appointed an attorney, the respondent number 2, for execution of this work, Lordship, on 1/12/2021 through a power of attorney, Lordship. And thereafter, Lordship, on 5/2/2021, respondent number 2 issued another power of attorney and entered into an agreement with the plaintiff for the execution of this work. Accordingly, the plaintiffs start construction in the year 2021 and they have proceeded accordingly as per the drawing and diagram provided by the...
Anyway, this is an RFA, isn't it? So
Yes.
you're unhappy with the judgment and order passed by what? This court?
Yes.
The court of senior civil judge, isn't it?
Yes, Lord.
So what is the
Yes.
decision of the senior civil judge? It
The
says
plaint was rejected, Lordship, under Order 7, Rule 11.
that,
Due to lack of cause of action against the respondent number 1. The whole plaint was rejected under the Order 7, Rule 11.
Okay.
Finding is that, Lordship, that...
because of the power
though
of
the-
attorney, is it? The power of attorney?
Yes, Lord.
Okay, so we'll
Page
admit the
60.
appeal, notice be issued, then we'll see.
My lord.
Isn't it?
Yes, Lordship.
Heard Mr. Tahir Amit Chowdhury, is it?
Yes,
Learned
Lordship.
counsel for the appellant. Now, in the last court date, you had prayed for further dates to get instructions from your client. What was
Yes, Lordship.
what instructions that you was
Actually,
required?
instruction, they were supposed to engage in senior counsel, but
Okay,
later on
okay.
they...
So you're being
that
engaged
is-
now.
Yes, Lordship.
Who has filed an
And
instant
copy has
appeal-
already served to the respondent, Lordship.
Who has filed the instant appeal against the judgment and order passed by the learned civil judge within brackets senior division -1 dated 07/02/2025, wherein the civil suit was dismissed, is it? By
Yes.
the learned trial court
Plaint was rejected under Order 7, Rule 11.
under Order 7, Rule 11, CPC. Full stop. Aggrieved, the appellant has approached this court in the instant appeal. Appeal is admitted. Mr.
Yes, Your Lordship. I have instructions to appear on behalf of the respondent number 1. I filed my power this morning.
Okay, Mr. Lalfa Koma, learned counsel, representing respondent number 1 is present along with Ms. Vanesami, learned counsel for state government, learned government advocate for respondents number 3 and 4. Okay, 1, 3 and 4, who is 2? Have you served notice upon respondent number 2?
Yes, Lordship.
We may await for return of service of notice from respondent number 2, list after 3 weeks. date.
Obliged.
Lordship,
Requisite
a fixed
copies
date
of
may
the
be taken up.
requisite copies of the appeal memo to be duly served to the learned counsels for the respondents, if not already done. Yes.
Obliged.
Lordship, a date may be fixed so that
Okay,
if
after 3
possible,
weeks on, give me a date. The vacation, then 1, 2, 3, should we make it, when? On 6th May?
Okay, Lordship.
On 6th, 5, 2025.
Obliged.
Highly obliged.
Item number 2.
Mayor is on number.
What is this, what is the stage?
My lord, the matter pertains to absorption of the RDA employees,
Ah,
the petitioners.
Yes, so steps are being taken?
My lord,
I think something is happening?
on last week, Friday, 4th of April, one affidavit is filed on behalf of respondent number 3, that is the secretary of the EPNAR. And from the statement in the affidavit, my lord, the stage, the development affidavit dated 4/4/2025
Yes.
at
Read.
para 6, my lord.
Yes, please
There
read.
was post creation on 21st of February. Thereafter, they have circulated the vacancy on 25th of February.
Okay, so it says that the final stage for appointments, slab absorption order will then be issued
Yes, my lord.
following the recommendation. So something is happening.
That is correct, my lord. And as per the affidavit, my lord, the latest development was on 27th of February, which is regarding the overage condonation application, which is yet to be considered. And they have stated that the case of the petitioners will be considered after the application form submitted by the petitioners are scrutinized. And this development which they have stated was on last week of February, my lord. Now we are in the month of April. So if this may be taken up again after vacation, fixing a date, and the counsel for the respondent may be directed to apprise this honorable court.
Yes, this is filed by respondent number 3,
Yes,
isn't
my
it?
lord. Yes, my
So respondent number 3 is the main,
The secretary of the DPNR,
yes, they're the main, so the,
it is the office of the DPNR who have to scrutinize the
DPNR.
application of the petitioners.
so respondent number 6 is Miss Mary L. Chiante, isn't it?
6 is the director of rural development. But this affidavit is filed by respondent number 3.
So respondent number 3 is represented by whom?
Same counsel, Miss Mary.
Miss Mary, isn't it? She's absent today. Okay, Mr. Victor L. Rante, learned counsel for the petitioner is present, while none appeared for the respondents. It is seen that the respondent number 3 had filed their affidavit dated 04/4/2025, wherein it was mentioned that you just make this para 6, okay, page 4, you flag it, within inverted commas. In view of the said affidavit filed, it appears that the respondents are taking certain steps in compliance with the judgment and order of this court dated 17/03/2022, passed in WPC 123 of 2021. In view of the above, we may await for the compliance report to be filed by the respondents. List the matter again after 3 weeks.
2 weeks, my lord.
We'll make it after the vacation, isn't it?
That will be after vacation, my lord.
Oh, okay, list the matter
If we can have it
after-
again on 24th or 25th.
List the matter again after 2 weeks.
Date may be fixed, my lord. 24th,
When do you want it? On?
24th,
Okay, 24th,
April.
4/2025. Yes.
Deeply obliged.
Item number 3.
Yes.
My lord, in this matter, the respondent number 10 has been represented by Ms. Mary and affidavit is yet to be filed. And as per the last order, a letter of intent has already been sent to the Northeast Frontier Railway authorities as well. And they have not been represented till date.
Yes, Ms. Zainab Sankwi, most probably. You're her junior, isn't it?
No, my lord. I'm the junior of Mrs. Linda.
Okay. But no one is here.
None has appeared, my lord. My lord, in a similar proceeding, Mr. Hitesh Jaishwal, Deputy Chief Engineer, was impleaded as a party in contempt case number 8 of 2022. So, my lord, kindly allow me to file an application for his impleadment.
Okay, impleadment application.
Yes, my lord.
Okay. Mr. Rokunga, okay, Pautu, learned counsel for the petitioner is present and prayed that he may be allowed to file an impleadment application. What?
For Hitesh Jaishwal.
What? Someone is transferred or what? To implead the
my
present
assumption,
incumbent? Huh?
My assumption is that there must be a change of authorities.
Assumption you don't know?
No, my lord. It's only my assumption.
To the present incumbents. Okay, in view of the above, list the matter, new para, okay, in view of the above, list the matter after 3 weeks.
My lord.
Find out what's happening.
My lord, I'm obliged.
4 orders. Item number 4.
Lordship, this is a delay application and all the respondents are represented and respondent number 1 to 3 has filed their written objection and respondent number 4, I have taken steps against the respondent number 4 by way of newspaper publication. That has also been completed and an order dated 16/1, it has been reflected in the said order about the notice deemed to be completed against the said respondents.
Yes. So,
Yes, Lordship, I'm appearing on behalf of respondent number 1 and 2, and we have filed a written objection.
so can we hear the matter today?
No, my respondent number 3.
You're represented, isn't it? Huh? So how many days delay?
112.
112 days against the judgment and order of what?
Judgment and order 27/4/2023.
So the appeal is on the grounds of what?
The appeal is on the ground, only basically on one ground, that the policy which was relied upon by the claimant, there is a specific provision for such policy that it should not exceed certain limits, basically 2.55 lakhs rupees. So therefore, the award cannot be passed beyond that. So the policy is annexed at page 41 of the main appeal.
Okay.
However, the tribunal has passed and granted relief, though it is filed under 163A. It has been the relief has been granted as per the.
Who's the claimant in this case? Claimant is represented?
Yes, sir.
Okay. Owner of the vehicle? Okay. Oh, so let's see the condonation application. What is the reason for the delay?
The delay, there is a delay of 112 days in filing appeal. The applicant is a company who is based in Chennai, the head office, and then there is a regional office in the Guwahati. And then my first ground for a delay is that is in page number 4, paragraph number 1. So the applicant had received the judgment and award sometime in the third week of May 2023 at Guwahati office. And then when the said judgment was scrutinized for a brief period of time, it was they have informed the legal department again about the said judgment and handed over the copy of the same. And then this was the first time it was communicated to the legal department about the said judgment and award dated 27/4/2023 for taking necessary steps. Then when it was handed over to the legal department during post internal negation discussions, it was realized that the case involves substantial stakes because of the fact that the policy had specific terms and conditions, and for which they have to file an appeal. And therefore, since they have found that such substantial stakes was involved, they have realized that they have no authority to decide the matter, and sometime in the first week of July 2023, a decision was taken that the matter has to be referred to the head office to take further necessary action as to whether appeal should be preferred or not. And then sometime again in the second week of July 2023, a decision was taken by the head office to take up the matter on urgent basis for filing an appeal before the Honorable High Court. And then as soon as it was decided that the appeal has to be filed, sometime in the last week of July 2023, the applicant appellant has a telephonic conversation with legal counsel at ISOL on several occasions with regard to the concerned matter so that an appeal can be filed. The legal counsel, sometime in the first week of August 2023, informed the applicant that appeal could be filed as soon as the connected documents are provided to him. The applicant immediately provided with all the connected papers to the legal counsel on the second week of August 2023, and after going through such papers, the counsel agreed to go ahead with appeal and do the needful. At page number 6 at paragraph number 5, the counsel spent another 2 weeks for preparation and for drafting an appeal after he received instruction from the applicant. Inasmuch as the documents were provided to the counsel by the applicant appellant, the counsel also took other steps for collecting the requisite documents which are necessary for filing an appeal. This exercise took another 2 weeks' time and was able to collect the documents in the second week of September 2023. Thereafter, when the drafting was completed, the same was forwarded to the applicant appellant in the last week of September 2023. It is 2020, and in order to officially vet the drafted memo of appeal, several procedures have to be complied with, and to complete with these requisite procedures, the applicant spent around 2 weeks' time to complete the said exercise. And when the said memo of appeal was the vetting of the said memo of appeal was completed, the same was furnished to the counsel on 27/10/2023. Then thereafter, without any further delay, the counsel had filed this instant application for condonation or delay of 112 days on 14 November 2023, after all the compliance and necessary steps taken. It is necessary to mention here that the application, the vetting for which the application has to route through is because the official needs is required for necessary procedures which cannot be expeditiously completed within a short span of time. And the reason is that there is no lack of interest or lethargy on the part of the appellant in filing the connected fresh appeal. Thereafter, another week was spent by the counsel for compilation and finalizing the application for condonation of delay, and immediately after this, the connected appeal along with the application are filed before this Honorable Court without any unnecessary delay. This is basically the ground for which the delay has been caused in filing appeal, Your Lordship. Though there is the 112 days of delay, the reason as mentioned aforesaid has been caused for filing this appeal. Therefore, the applicant is submitting this application for condonation of delay, and 112 days of delay caused in filing an appeal may be condoned, and the application may be allowed, the appellant may be allowed to contest the case on merit. This is my humble.
No documents. And
Yes.
next, when was it
Basically-
handed over to the legal dog? Nothing.
Yes, no. In this case, there is no documents annexed.
Very
Yes.
casual, huh? Anyways, yes.
Lordship, as I have said, the instant in IA does not bear any documents to prove his submissions and explanation.
So what do they have to prove?
It is evident that they have received the judgment and award dated 27/4/2023, sometime in the third week of May 2023, at the Guwahati office. However, no date of receipt for the judgment and award is annexed herein. Moreover, the pronouncement of judgment was duly fixed by the learned tribunal, and this is not explained, and this is not explained in this application as to why the insurance company did not have any knowledge about the judgment and award dated 27/4/2023. So the instant application is just is just an application in general, without no documents to prove his explanation. Even a single document is not annexed.
What documents do you require?
Lordship, the receipt of the judgment and award dated may be annexed herein to prove that the 3 weeks on the judgment and award was received on the third week of May 2023.
Okay, judgment was 27/04/2023, isn't it?
Yes,
When
Your
is the appeal filed? On
November 2023.
November 2024. Which date?
14.
14th November.
Yes.
Okay, yes. Continue.
Furthermore, Your Lordship,
It is 14 November 2023.
2024.
Three.
Three.
Yes, the same year.
Oh. Okay. From April, November. Yes.
Yes.
if I
Please
may, Your
continue.
Lordship. Yes. Furthermore, Lordship, the applicant has submitted that after receiving the judgment and award dated 27/4/2023, it was sent to the legal department of the company. However, there was no submission or documents to prove this that this judgment award was sent to the legal department of the company. So, a
So it
delay
was
of-
sent to the legal department on first week of June, is it? Is it? First week of June, 2023?
First.
I'm reading page 4 of your objection.
Yes.
So, on the first week of June 2023, the legal department was informed, isn't it? How long did the legal department take to decide to file an appeal?
2 months, Your Lordship.
Okay, after about 2 months.
Yes.
About 2 months, it was finally decided that, so is there any negligence on the part of the legal department?
The negligence
2
may be
months,
proved by
yes.
that there was no, it was left unexplained. It shows that there was ample time for the applicant to discuss the matter with the concerned department,
Okay,
Your Lordship.
yes, yes.
This
Then
is
it
a-
was referred to the head office.
Yes.
When was it sent to the head office? July.
Yes, Your Lordship.
July
2023.
2023, it was sent to the head office to take necessary action. Okay, no documents to show that it was sent to the, where's the head office? Guwahati?
Chennai.
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 So you're saying that there are no documents to show, isn't it, huh?
Yes, Your Lordship.
Oh. Okay. No material evidence to show that it was sent to the head office, yes. Then para 7, read para 7.
That with regards to para number 1,
Yes.
subsection 3, the applicant stated here that the head office decided to file an appeal in the second week of July 2023. In this regard, it may be reiterated that here that there is no documentary proof in order to show that the final decision was made at the head office. Again, the whole month of July 2023 is left unexplained. It is surprising to say that a day-to-day explanation may not be insisted on by this honorable court, but the applicant has no attempt to give a week-to-week explanation or even a month-to-month explanation found in this application. As such, the delays were nothing but gross negligence on the part of the applicant, and hence this application is liable to be rejected.
Okay. Yes, then the other respondent, we're done. Any this thing to rely on? Any authorities?
I have one authority from my side.
Okay. Any authorities? No.
No, Your Lordship.
Okay. Yes.
My Lord, in this case, there has not been any reasonable and cogent explanation for the delay. That is one thing. And the applicants were aware of the judgment and order, and it was only on the third week of May that the same was forwarded, and the head office had, and the same was forwarded on the first week of July to the head office. And
Okay, her facts
the
and
only
all,
steps-
same
yes,
thing,
my Lord.
don't repeat what you have said,
My
huh?
Lord, my Lord.
Yes.
And it
Any
was only-
authorities to rely on?
No, my Lord.
Okay. Get some authority so that you can, this thing, isn't it? So many authorities concerning why condonation should not be allowed, isn't it, huh? Simply giving facts, just that, then you should strengthen your argument by giving some authorities where there are certain grounds where condonation should not be granted. Come prepared, yes.
I have one authority to rely on. This I would like to place this.
We'll continue again tomorrow, get some authorities. Okay,
Ma'am,
along with, yes,
tomorrow-
what is your authority? Make your argument sharp. Get some authorities, show some passion that you don't want it to, the condonation to be allowed, isn't it? Not just simply coming and giving this. So then the court can consider your case
Your
properly.
Lordship, this is 1987 2 SCC 107. Collector Land Acquisition and another. SJ Katiji and others. Your Lordship is well aware of this. And in the next page, at page number 108, paragraph number 2 and 3, I would like to rely on those two paragraphs.
Yes.
Paragraph number 2 says that refusing to condone delay can result in a meritorious matter being thrown out of the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merits after hearing the parties. Number 3, every day's delay must be explained. Does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. This is paragraph number 2 and 3 is, I would like to rely on those two paragraphs to substantiate
Okay.
my claim.
We'll continue again tomorrow. Come up with some authorities. Don't bring lots. 1, 2 good authorities, and also the appeal. Okay, is there a reasonable ground for filing the appeal? Because it says that the insurance coverage is only for so and so.
Yes, that is.
Then what happens? It will be the owner who will have to pay the rest of the amount.
The liability is to the extent that the company can pay 2.55 lakhs.
So
That
who is the owner of the vehicle?
I am the owner.
Then you should really fight for your case, isn't it?
This is the third party coverage.
Yes. Heard Mr. Subedi, so-and-so, Roshan Subedi, learned counsel for the applicant, along with, do you have any authorities on only it? I can dispose it all like this
I
also.
will have the authorities, ma'am.
Along with Mr. Rokum Pauthu, learned counsel for respondent number 3, and Mr.
Michael Fatou.
So-and-so, learned counsel for respondent number 1 and 2. The learned counsels for the respondents have prayed for time to produce the authorities they would like to rely upon. In view of the above, this is matter for further hearing on 8th. Tomorrow is 8, isn't it? 8/4/2025. Yes.
I'm open for lunch.
Item number 5.
me, please, Your Lordship.
Yes, what is the IA about?
This is an application for continuation of delay of 335 days.
Oh,
Notice has already been completed, my lord. And in the last court date, my
so
lord.
have you filed your written objection?
No, my lord, we will not contest.
Not contesting?
Yes, ma'am.
Both the respondents? All the respondents?
Yes,
Okay.
lord.
What is the reason for the delay?
Yes, my lord, the impugned judgment and order was passed on 4/10 of 2023, and the last day for filing this appeal was on 2nd of January 2024. And I have filed this appeal on 2nd of December 2024, so there has been a delay of 335 days. So my reasons is that when this judgment and order was passed by the senior civil judge, the applicant was only informed after 49 days, that is on 22nd of November 2023. And when he had approached his previous counsel, his counsel in the trial court, he was advised to engage a new lawyer who could file an appeal for him. So during this time, 61 days has already elapsed. He keep on urging his counsel in the trial court that what steps have to be taken and all, and he was advised that a certified true copy of the judgment and order was required for filing of an appeal. So if I may take your lordship to page 11 of my application.
Ele- 11 of your application is the judgment.
Yes, yes, Your Honor. Yes, my lord. I'm sorry, I apologize. On the top portion, the date of application for the copy is 6th of March 2024. And the date of making over the copy to the applicant is 20th of March 2024. So,
Okay, a few
so-
days, few weeks.
Yes. Then there is a delay of 21 days during this, when copy was received by the applicant. So when all the documents were collected by the applicant, she approached one lawyer. Her name is Saimoi, Miss Saimoi, but that lawyer is currently holding a post of assistant government advocate in the district court.
Okay, so basically it's due to the fault of the councils, not yours.
Yes, yes.
Because once you became
not-
aware, you took steps. Is
Yes,
it?
yes.
Okay,
Yes, Your
fine.
Honor.
Anything to rely on, authority?
I have one judgment.
Para?
Yeah.
Nine.
Paragraph number 8.
Okay.
On the 5th line, during these days when everybody is fully occupied with his own avocation of life, an omission to adopt such extra vigilance need not be used as a general to depict him with drastic consequences. And your lordship, at para 11, rules of limitation are not meant to destroy the rights of the parties. They are meant that the parties do not resort to dilatory tactics but seek the remedy promptly. So,
Okay, so you took prompt action, but it was
Yes.
your counsel
yes,
who had
yes,
delayed.
Your
Okay,
Lordship.
fine, not objected, no objection is raised. So we'll allow, just record their names. Okay. Ms. So-and-so,
H. Lerausangi.
learned counsel for the applicant is present, along with Mr. Yes.
My lord, if I may, if the LCR can be called upon and
Okay.
paper book be prepared, my
Yes.
lord.
Along with Mr. Ricky, isn't it?
Yes, my lord.
J.H. Ricky Ludward Feller, learned counsel for respondent number 1.
1.
And Ms. Lal Nundui, learned government counsel for respondent, for the state respondents number 2 to 4. Okay. So I'll pass the order, full order later. IA allowed disposed. Now in the main RFA. Again heard Ms. So-and-so, learned counsel for the appellant. This is an appeal filed under section 17 within brackets 2 within brackets small b of the Mizoram Civil Courts Act, 2005, read with section 96 CPC, 1908 against the judgment and order dated 04/10/2023 passed by the learned senior civil judge -4, Izol in declaratory suit number 37 of 2016. Full stop. What is the reason? The learned counsel for the appellant submits that there are sufficient reasons for setting aside the said impugned judgment and order. Ground?
Yes, Your Lordship, if I may take Your Lordship to page 14.
40?
14.
14.
I have an unregistered sale letter with 1 Shangli and Tsunga, and the respondent number 1 has a sale deed that is registered. With
Since
that
the
sale-
learned trial court had relied on an unregistered,
Yes.
unregistered sale letter while deciding the case against the present appellant. Full stop. Appeal is admitted. Issue notice to the respondents. Again, Mr. Ricky so-and-so, learned counsel, accepts notice on behalf of respondent number 1. Is it? While Ms. Lal Nuntui, learned government advocate, accepts notice on behalf of the state respondents number 2 to 4. No need to issue formal notice. Requisite copies of the appeal memo to be duly furnished to the learned counsels for the respondents. List after 3 weeks. Meanwhile, LCR, TCR, okay? TCR to be called for.
Obliged, Your Honor.
Items number 7 and 8.
Yes.
My Lord, counsel for the appellant is on leave. He has submitted a letter of absence. So I talked to him on phone. He wants the matter be listed after vacation. That is in a week commencing from 22nd April.
Okay, so appeal has been admitted.
Already, my Lord. And
Appeal is
LCR also
admitted.
has been received.
So now respondents are also represented, all the
Yes.
respondents you are representing?
My Lord, my Lord.
So this matter can be listed for hearing?
Yes, my Lord.
Cross objection is also there?
There, yes, my Lord. Paper book is not required, my Lord. I have enclosed all the
LCR is received?
receipt
Okay.
already, my Lord.
Then Mr.
Michael Pacha.
So-and-so appears on behalf of his senior, Mr. Johnny L. Tauchong. Is it?
Yes, ma'am.
Learned counsel for the appellant. Along with Mr. L.H. Yanshima, learned counsel for the, all the respondents.
Yes,
is
my
it?
lord.
For all the respondents. It is seen that TCR is received. In view of the above, matter to be listed for hearing. Any date?
In the week commencing from 22nd April.
Okay. Matter to be listed for hearing in the week commencing from 22nd April
My lord.
2025.
Obliged.
Yes.